So, you're considering competing in a witness examination competition? Blackstone Society has put together a handy instructional video to help you start off on the right foot. Witness examination helps you develop your public speaking skills, learn about rules of evidence, and most importantly, have fun. First off, you'll need to know if you're flying solo or competing in a team. For the UWA first year competition, you'll be competing in teams of 2, so find a friend. But for the UWA Open competition, it's every man for themselves. Then you'll need to find out which side you'll be on for that round. For the Open competition, you'll simply be either counsel for the prosecution or counsel for the defence. But for the first year competition, there are senior and junior counsel for each side. Every competitor will need to provide a witness for each round. Be sure to check the competition rules, available on the Blackstone website, for eligibility details. For the most part, anyone is appropriate. Friends, family, partners, Tinder dates. It's fun and easy to be a witness. You can generally expect to receive the question the day before your round. The question will contain witness statements, the court in which it will be heard, and the relevant law. Everything you need to know for the round is inside the question booklet. You do not need to refer to law outside of that provided to you. You also do not need to refer to case law at any point. While it may be tempting to surprise your opponents, don't do it. It's considered unsportsmanlike and will lose you points. There are 4 key parts to a witness exam competition: opening statement, examination in chief, cross-examination, and closing address. The opening statement is your opportunity to set the scene, make a good first impression on the judge, and signpost how you're going to make your argument. Next up is the examination in chief. This is where you get your witness to tell their side of the story, as established in the witness statements. The best EICs are where the counsel elicits the witness's evidence in a natural manner without feeling rigid or forced. In an EIC, you'll want to ask open questions, that is, questions that wouldn't normally be answered with a simple yes or no.
What was taken?
It was my watch. My father gave that to me before he died. And what makes it worse is that I know who took it. It was Jonathan Snow. He took the watch!
Next comes cross-examination. This is where you ask questions of the opposing witness to weaken their argument and strengthen your own. You could do this by demonstrating that the witness couldn't possibly accurately perceive or recall the events in question, was mistaken, biased, or had a reputation for dishonesty, or had made prior inconsistent statements. Accusations of lying are particularly severe though, so you should only allege untruthfulness if it is completely justifiable and demonstrable to the court. Unlike examinations in chief, you should ask closed questions in cross-examination. That is, questions that only require a yes or no answer. If your witness is not cooperating, make sure that it's clear to the judge, then politely ask for a yes or no answer. Finally, there's the closing address. This is your chance to tie everything together. Generally, you'll want to prepare about half of your closing statement beforehand, including restating your case theory and giving an overview of what you've tried to argue. The other half should be adapted to what happened during the trial. This is where your improvisation skills can shine, since you'll have to come up with most of this on the spot. Once you've finished your preparation, all you'll need to do is pick out an outfit for the night. Dress smart, but you don't need to go over the top. Once you've signed in with the competition director, you will be assigned a witness. You cannot give your witness pre-prepared documents, and there are limits on the annotations that you can make to the provided statements. Primarily, you should focus on the sort of questions that they could expect in examination in chief and cross-examination. Once the judge is ready, you'll need to do appearances. An example of a good appearance is this.
May it please the court, my name is Miss Rumble and I appear alongside my learned junior, Mr. Riley, for the defence.
During the opposing counsel's EIC or cross-examination, you may object to something either they or the witness have said if it violates a rule of evidence. In order to object, simply say, politely but confidently, "Objection, Your Honour," then state the rule of evidence that has been violated while standing up. At this point, the judge will either dismiss your objection, allowing the opposing counsel to continue, accept your objection and direct the offending counsel to amend their questions appropriately, or request clarification from you as to the grounds of your objection. Hearsay evidence is objectionable. This is where a witness gives evidence based on what another person has told them. This rule does not apply where the other person is also appearing as a witness.
So how did you hear about this, Miss Targaryen?
Oh yeah, my cousin's dad's dog sitter's friend told me that they totally did it.
Objection, Your Honour. This is hearsay.
I'm inclined to agree, counsel. Objection sustained.
A witness should only give evidence based on what they saw, heard, or perceived. Almost anything else can be classed as an opinion, which is not admissible and is objectionable. There are a couple of exceptions to this rule, such as qualified experts being able to offer opinions on topics directly related to their area of expertise, or an ordinary person drawing reasonable inferences from what they've seen.
After I saw him drink his 17th shot of tequila and start hitting on a coat stand, I started to suspect that he might be drunk.
Objection.
On what basis, counsel?
Opinion, Your Honour.
Do you care to respond, Miss Walker?
Your Honour, the inference was reasonably open to my client in the circumstances.
That makes sense, Miss Walker. I'll allow the objection.
If the opposing counsel is being particularly aggressive towards your witness during cross-examination, you may object on grounds of badgering the witness. However, keep in mind that the bar for conduct to be considered badgering is quite high.
Would you say that you're an elderly lady, Madam Meyerowitz?
No, I'm only 40.
But 40 is quite old, isn't it? That would make you an elderly lady, Madam Meyerowitz.
No, I'm in my prime time.
But you're elderly. You're old. 40 is
Objection,
old.
Your Honour. He's badgering the witness.
I agree, counsel. Can we please reframe or move on?
Mrs. Meyerowitz, do you have more yesterdays than tomorrows?
If counsel are leading their witness in their examination in chief, such as putting words in their mouth or asking closed questions, you can object on grounds of leading the witness.
And you can't have killed him because you don't even know how to use a knife, do you?
Objection, Your Honour.
On what grounds, counsel?
My learned friend is leading the witness.
Objection sustained.
One last thing to be aware of is the rule of evidence known as the rule in Brown and Dunn. If you wish to lead evidence that directly contradicts what a witness has said, such as accusing them of lying, you are required to put the alternate version of events to that witness. Feel free to do this in a creative way. The rule simply mandates that witnesses be given a chance to respond to the accusation, not the way in which you say it. This is by no means a conclusive guide. There are excellent resources available on Blackstone Advocacy if you want more information on particular types of objections. And now you're ready for your first witness examination competition. Thank you for watching. Check out the Blackstone webpage for competition details, rules, and more information through Blackstone Advocacy.